Your Honor, Cusky on behalf of Trevor McLeod.
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
One Goodish, one county prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter.
I do see that the new charge is set for an arraignment on September 10th. It was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice. Or one time which led to his incarceration and his sitting in bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you, Ms. Gooders. People's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract.
All right, buckle up, because today's video is a masterclass in how not to handle yourself in court. We're dealing with not one, but multiple sovereign citizen encounters across different courtrooms, different judges, and wildly different outcomes, all tied together by the same core belief, that saying the right word somehow makes the law disappear. Spoiler alert, It doesn't. What you're about to see is the collision between internet pseudo-legal theory and real-world courtroom procedure. We've got defendants refusing lawyers, rejecting driver's licenses, denying jurisdiction, and confidently declaring themselves living men, as if that's some kind of legal invisibility cloak. And on the other side of the bench, judges who've seen this movie 100 times and know exactly how.
You have appears to be duplicate charges, so some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not receive to the, I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am, I don't consult.
And there it is, the phrase every sovereign citizen thinks is a legal cheat code, a living man. This line didn't come from a statute, a case law ruling, or any recognized legal authority. It came from internet forums and self-appointed gurus who promise immunity from the law if you just reject the legal fiction version of yourself. Courts, however, do not recognize separate versions of human beings based on word choice. Notice how the judge doesn't immediately argue the point. That's intentional. Judges don't debate fantasy, they manage reality. The courtroom isn't confused by this declaration, it's unmoved by it. And that's important. Sovereign citizens thrive on the idea that if they can force a semantic debate, they can derail jurisdiction. But jurisdiction isn't established by magic words, it's established
For that, then when they're putting on me, they found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, man, this is going to get thrown out because the officers were just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here, so when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings, though, and I do not accept the terms, like.
Okay.
Yeah,
Well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, ma'am.
Okay.
That with what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, I thought I had to deal with Fulton County on that instead of Clay.
Looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me?
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park, it is on or around July 28th. It happened. So that is not the Fulton County one that appears to have happened around July 17th. So there's
Clay County.
Yeah, if the warrant was sworn out for Clayton County, yeah.
Okay, ma'am. That's all I was asking, because I know that's gonna get handled. That's some BS.
This sequence right here is where things quietly go from bad to worse. Watch how every question the judge asks is an opportunity for the defendant to protect himself, and every answer he gives does the opposite. Refusing counsel. That's his right, but it removes professional guidance. Rejecting a driver's license. That signals defiance rather than cooperation. Turning down a plea offer. That eliminates the easiest off-ramp available. What makes this moment so telling is how calm the judge remains. There's no frustration, no pressure, just documentation. Every "no sir" becomes part of the record. Sovereign citizens often believe that refusal equals power, but in court, refusal just limits your options. The judge isn't losing control here, the defendant is.
The man even told him, hey, yes, he owner, he's the owner. And they still, hey, let me search you and all that. Now, once they searched and seen, I was clear, I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck, I was renting out at the time.
Mr. Whitlock, I'm gonna stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go for it and explain it.
I need some professional help, like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you could tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am, but even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are next.
Special representation. I'm
Same
asking,
as last defendant, Your Honor.
my honor, I'm asking, what is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your.
So, Deputy,
Yes, ma'am.
I would like to know your
so
nationality.
he has charges in jots and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
Know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
I'm asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again, my honor,
Is he deputy?
status
Say it
of
again, Your
everyone in the
Is
courtroom.
he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S. citizen?
Deputy, do you believe that this gentleman is?
This is what legal word salad looks like. Mispronounced Latin. Half-remembered doctrines. Invented distinctions that sound impressive but mean absolutely nothing in practice. Sovereign citizen arguments rely on overwhelming the room with confusion, hoping someone blinks first. But here's the problem, they're arguing with people whose entire careers are built on precision. The judge's response cuts straight through the nonsense with humor and authority. That living brain donor line isn't just a jab, it's a signal that the court is done indulging this fantasy. At this point, the defendant believes he's laying the groundwork for some brilliant jurisdictional trap. In reality, he's just talking himself out of credibility. Courts don't reward clever-sounding nonsense. They reward compliance.
A U.S. citizen. Are you a U.S. citizen? My Honor, are you a U.S. citizen?
Sir, be quiet.
Are you a U.S.
Yo.
citizen?
I said
Said
be
stop.
quiet.
Are you
Be
a
quiet.
US citizen? What is your name? What is your status? What is the status
Yo,
of everyone in the
chill.
courtroom? That's what I'm asking.
All right. So y'all just go ahead and take him back. I'll just go ahead and put the bond. Y'all take him.
Feet up,
Asking
move your
for
feet.
the court to be a jurisdiction of the
Hey,
court.
you might want to chill
Court
out.
to be challenged. I'm challenging the jurisdiction of the court. Challenging the jurisdiction of the court because I am not who they say I am challenging the jurisdiction.
This is the moment that shatters one of the biggest sovereign citizen myths, the idea that the court needs your permission to proceed. It doesn't. When the defendant refuses to plead, the judge simply enters one on his behalf and keeps moving. No debate. No delay. Process continues. Notice how methodical this is. Bond is addressed. Trial dates are set. Pretrial options are offered. The court doesn't punish defiance emotionally, it neutralizes